So welcome this day of 18th October 2024, Friday. This is a recording of Conveyancing, April 2024, the paper that was done in April 2024, the latest, part 1. Part 1, I'm going to cover 1, 2, 3 question 1 to 3. Then part 2, I'm going to cover question 4, 5, and 6. Conveyancing is one of the most difficult subjects at Kenya School of Law. In fact, the people who, this is one of the subjects which student pass the last. The people who have receipts, which many which I know, which I have talked with, they usually have conveyancing and commercial as their receipt, their final subjects to do, commercial and conveyancing. So my name is James Nginya. I was in KSL in 2015. I did research of past papers, which I have uploaded on by exam preparation website. For conveyancing is the paper which I have researched so many subjects. I have researched all the papers, recognizing that is one of the most difficult subjects. So year 2008 to 2019 combined, go for 500. April 2021, 100. November 2021, 100. April 2022, 100. October 2022, 100. March 2023, 100. November 2023, 100. So a total, if you are to purchase conveyancing papers on the website, you are going to use 1,100 only. So if you want to pass this subject, you need to understand the Land Act very well. You need, and its regulations, which are under it. So, and also the Land Registration Act and its regulations. Then you need also to understand the processes. Any question you are dealing in conveyancing, you must talk about the process. And reading is one thing, and application is another. When you're talking about the processes, you must talk about Adisasa, because everything is done on Adisasa these days. You also need to know the specific acts of Parliament which deals with specific topics. For example, section of properties topic, you must know the Section of Properties Act and its regulations. Community land, you must know community land and its regulation. But generally, you need, first of all, to grasp the Land Act, its regulations, land registration and its regulation, and know the processes, because any question involves the processes. So the Land Act subsidiary registration that you need to know are the land allocation, public land regulations, the land assessment of just compensation rules, the land conversion of land rules, the land extension of renewal of leases rules, and the land regulations. So for the Land Act, Land Registration Act, subsidiary registration, you need to know the forms, regulations. Most importantly, the Land Registration General Regulations of 2017, the Land Registration Unit Orders, the Land Registration Electronic Transactions Regulation, and the Land Registration Units Order 2023. But the most important regulation here is the Land General Regulations of 2017, which has the processes and the titles. Welcome, Helen. You can hear me? You can hear me? Unmute.
Hello.
Yes,
Hello.
I can hear you.
Okay.
Hello, how are you?
I
You can
am
hear
well.
me?
How are you? Yes, I
Fine,
can
thank
hear
you.
you.
Okay.
Okay.
You can see the paper projected there.
Yes.
So I had done the introduction.
Okay.
I said if you want to pass land conveyancing, you need to understand the Land Act and Land Registration Act and its subsidiary registrations. And the Land Act subsidiary registrations are Land Act allocation of public land, which deals with the allocation of public land by National Land Commission. Then the Land Assessment of Just Compensation, which deals with compulsory acquisition. There's a question that came in April 2024. An answer was direct from here. We are going to tackle it. The land conversion of land rules, which deals with the conversion of lands into various categories. The land extension and renewal of leases rules, which deals with the renewal of leases. And the land regulations. So under the Kenya Law website, under Land Act, you are going to see that those registration. You must read and understand. Then the Land Act, large registration regulations include the most important here is the Land Registration General Regulations, 2017, which has the forms and the processes. Because for each and every conveyancing questions, you must talk about the process. So this is what you need to know. Then I said also that there are specific acts of parliament that deal with specific topics, like Community Land Act. You must understand it to tackle community land topic. Also, section of properties, you must understand it to deal. Section of Property Act and its regulation to deal with a question that deals with the section of properties. But generally, the most important thing is the Land Act and Land Registration Act and the Land General Regulation and the subsidiary registration under the Land Act and the Land General Regulation 2017. So you must make small notes on that. You must understand, maybe make what revision chart or something. So we are going now to enter into the paper itself. And I also said that all the papers
Mhm.
under this subject have been researched and are there on the website. Karibu sana Kate. So I said that I have researched all the past papers under this subject. And from year 2008 until November 2023, the only paper that I have not researched is this April 2024. And these classes, for the purposes of this, I usually say between this Zoom recording and the paper that is researched in the website, the paper in the website take precedence because it has more details, and I can review any answer anytime and upload a new answer by my own motion or by review by a student. So this I usually do as a stopgap measure before the exams, because of course research takes a lot of time. So between a paper that is in the website and what is in uploaded in the website, in this YouTube channel recording and the paper that is uploaded on the website, the paper uploaded on the website takes precedence. So I'm going now to enter into this questions. We are going to deal with question 1, 2, and 3. Then tomorrow, question 4, 5, and 6. So I'm going to read the question now as projected on the website, on here on Zoom on the screen. So I said every time you are reading a question, it is a story. So you must understand what the examiner is asking, because not all the facts in the question are relevant. So you must know the keywords. So Genonian Moskovich is a Yugoslav businessman in the hospitality industry. He has established the mega hotels, resorts, and campsites around the globe in partnership with associates and friends. He recently landed in Kenya and set out on African safari with his associate through the Masai Mara. They drove through the Narok East, approximately 200 kilometers from Rewa Conservancy, where they found a very rich and vast indigenous forest belonging to Kitiri community spanning to 10 of thousands of acres. They noted a few wild animals roaming through the forest and decided to camp for the night. In the morning, Jaconian's team spoke with the local Maasai's who confirmed the land is community land. So now this is where the conveyancing starts. The question is now telling you this is community land owned by Kitili community. Jaconian and his associate love the forest and want to set up the campsite in the region through a registered lease of 40 years. They also wish to enjoy exclusivity as against any other potential campsites, but the locals are willing to demarcate 2,000 acres with painted wood pegs because there are no other campsites under sections where the locals reside. They are also expected to conserve the environment through all the means possible and create jobs for the local tour guides or morans willing to accompany the tourists through the forest. Number one, they have approached A1. They have approached you officers seeking a legal opinion on the procedure to be followed to obtain a lease over the said piece of land. proceed, and advise. So the question is very direct, legal opinion. So if it is a legal opinion, you do legal opinion according to your legal writing and drafting class. Yeah, the address to this Yugoslavian. So you must be knowing how to do a legal opinion. So obtain a lease. So this is a lease over the said parcel of land. So the question was asking about lease over the community land. 6 marks. So that is how you interpret this question. So uh, so Helen, what do you think?
I for a lease. I haven't got an opportunity to go over the paper. So maybe if I take time and try and gather myself, then I can try and remember the little that I can
Okay.
about it.
Sawa sawa. Kate, how are you?
I'm very fine, Mwalimu. How are you, sir? Hi, Helen.
Hi, Kate. Hi.
Very well.
So
Sorry, I was changing gadgets. I know you asked a question. What was the question, sir?
the question was,
Mm-hmm.
we are dealing with April A1.
Yes.
Now the lease over the said parcel of land.
Yes.
Of course, the question is community land direct.
Yes.
So lease, when someone give an opinion on how someone who want to lease a community land.
So I think let me just check through my notes. But the first thing for community land,
Yes.
you must understand the structure of the community in terms of where the decisioning council starts, and then you must get the relevant approvals. Now, depending on where the land is, and I think from, if I was to pick some of the information that is there, that there is wildlife roaming around that area, you would need to get consent over and above the community. It is likely that maybe a wildlife service is around that area. You might need to get consent around that. I think those are the two main things that I see for community land, and taking the aspects that are in the story.
Okay. Yes. That's a very good trial. So you get some marks if you are doing that. You had answered that way, but of course not the full marks.
Yes. What else would we, your guidance on, like, what else you would capture? Because in my view, if I only have 2 points, I think I wouldn't get more than, in my view, 3 marks.
Yes.
What other aspects in this would I need to capture?
So I said,
yes.
So I said it's a legal opinion.
Yes.
So every time you are told to do a legal opinion, you must do a legal opinion, whether in civil procedure, civil litigation, conveyancing.
Yes.
So
Yes.
you are the lawyer now advising this Yugoslavian. And of course, the question has already talked about these are community land.
Yes.
So this question is asking you, is generally testing your knowledge on community land.
Yeah. Oh, sorry, Mwalimu, can I try? So I remember, and I was trying to get my notes because I
Okay.
remember I had put it together. So from my studies, so for community land registrar, you have to get the cadastral map showing the extent of the community land and identified areas. So that's the first thing. So first understand this piece of land that you're looking to get at, like what is the breadth and width of it, the name of the community. You have to understand the register of members, the users of the land, because community land has aspects of the ability of how else that they use the land and what restrictions are likely to be there. And then identify the identity, like figure out, because this information is registered in the registry, the identity of the members who have been identified as group representative. And then it is said that any instrument that disposes of any rights of the community land has to be in accordance with the community guidelines. So it means you will need to know what the community guidelines are and ensure that the registration of that lease, which is now the instrument that will be giving you the powers, is done in accordance with the community guidelines. Yeah, so this I think came from when I was reading the LRA. Yeah.
So yes, you have tried.
Yes.
You have tried. That is a very good try. So
Thank you,
I
Mwalimu.
say yes. When I was introducing this class, you had not joined. I said that any question you are asked in conveyancing,
Yes.
you must talk about the process sequentially. Unaona? So
Yes, Mwalimu.
sequentially, you must talk about process sequentially. Unaona? So the first step will be, and you have spoken about it, is first of all they need to ascertain that this is a community land. That is the first step. Then they do a search, and you have said that do a search on the community land registry.
Yes.
And that search it is going to give you the registered officials and whether it's a community land and whether it's a community land and its registered officials.
Yes.
So that is the first step. The second step, because you see, when you are dealing with the community land, you are always dealing with its officials.
Yes.
So the next step is approach the community land management committee with a proposal to release those acres in the question. So that is the second step. 2,000 acres. Of course, they have known the officials, and the land management committee is of course defined in the Land Act and land registration.
Yes.
Then after that, the land, if the land management committee is satisfied with the proposal, then they are going to approach the community assembly. Section 15(5) and 31(1) of the land of the community land act. The assembly needs to pass any deposition, and I can lead.
Yes.
So a registered community shall have a community assembly which shall consist all adult members of the community. The quorum of the decision making by the committee shall be not less than 2/3. That is section 15.5. I read section 15.5. Any decision of the registered community to dispose or otherwise alienate land shall be binding if supported at least 2/3. While other decision of the registered community by shall be simple majority. So this is not alienation. This is just leasing. So the decision of the community assembly shall be by simple majority. Read together by section 31(1) of the Community Land Act. Yes, so the land, the community assembly passes a resolution through the simple majority approving the lease. Then the land management committee through its registered officials, which is the chairman and the secretary, enter into a lease agreement with this Yugoslavian, the leasee. So the lessor will be the land management committee through its chairman, and the leasee will be this Yugoslavian. So they enter into a lease agreement. So that is another step. So then this is a lease of more than 2 years because it's for 40 years. So it needs to be registered. So now this is knowledge of your Land Registration Act, which talk about registration of the leases. I don't know which the section it is. So the lease, after the lease agreement is done, the lease is registered with the registrar of leases. And then that registration is noted in the community land registry. So for any person who can search the community land registry, we know that this community, the Kitili, this Kitili community, through its officials have given a list of for 40 years of its 20,000 acres. So that was the answer. This is a question that have never been asked in the past. So this was not a very easy question, and but Community Land Act generally questions have been asked. I think the last time they were asked was 2016, 2017. If you look at the Q&A, you will see. So generally, it's needed you to understand that a lease of a private land, have been asked many times in the past. And in the Q&A, you can go and look at the lease of a private land. Lease of a public land has never been asked. So that is a question you go and investigate. That is a prediction I'm giving you. Go and investigate.
Could you please repeat?
I'm saying
yes,
the lease of a public land
has never been asked.
Has never been asked. Where you involve the National Land Commission, eh?
Yes.
So look at your section 20 of the Land Act and other relevant provision, eh? So that is it. So we can go to the next question.
So sorry, in your view, because it has never been asked, it may be asked.
It may be asked.
Okay.
It may be asked.
Okay, understood.
Sawa. So upon probe, you have realized that the Ministry of Lands, in conjunction with the National Land Commission, is in the process of demarcating the residential region of the community, as well as processing freehold titles of the individual community members. In light of this development, discuss the steps to be followed in privatization of the community land. So Helen, what is this question asking you?
The conversion of community land to private land.
Sorry?
Conversion of community land to private land.
Very good. Conversion of community land to private land. So also you need to have read the Community Land Act and its regulation to know the conveyancing. Give it a try, Helen.
First of all, okay, let me start with notice.
You are not clear?
Okay. Can you hear me now? Can
Yes,
you hear
I can
me?
hear you. Yes.
Okay, before notice, I believe
Yes.
either the National Land Commission has to be involved. The National Land Commission has to be involved. Notice has to be issued to the members of the community. They have to be given an opportunity to give suggestions or objections. So there has to be a meeting where both parties present their case, if I may say. Then after that, after a conversion happens, of course, something has to happen to the register. I'm sure the community land, the register is closed and a new register is opened. If there is need for, I don't have the proper process, but I believe that has to happen somewhere.
Okay.
So could
That
I
is
make an attempt?
Yes, yes.
Okay, I think on this second part, if I was to pick what you had mentioned previously in terms of the threshold. So
Yes.
first, the privatization is delineating the rights of the community, which means the assembly has to, by 2/3 majority, make approval of the same. Now, the other bit of this privatization is that the next bit they're saying that the titles are going to go to the individual community members. So there must be a verification of who the community members are, whether they align with the register that is in the registry, because their names are in the land registry. Then because it is a land transaction, the titles will go to the adult members of the community because it's a conveyancing transaction. So the steps around that, so after the identification of the relevant members, the relevant notices, and the relevant threshold of the decision has been made, then the process of creating titles is under the LRA, and it would follow that process where there's now that application with the relevant documentation that is filed, and the process of application is done. I think they'll need to be an involvement of, I think, a land surveyor to sort of share out the land, mark out the relevant boundaries, because then there'll be an update to the cadastral plan. So after that has been done, issued, approved, then the titles will be issued. Now, moving further for whether it's residential, now to demarcating it to residential region, the titles now will have that annotation that it is now a residential area. That's just perhaps my view.
That's a very good answer. You need you see that, like, this question is 5 marks, eh?
Yes.
So in an exam you give 5 points, eh?
Yes.
And
okay.
a point is a mark. Then that's how that's the strategy of answering a question, and you do step by
step.
So
okay,
I want to put your thoughts now in step by step, eh?
Yes.
So remember, these are the individual members of this community. So the individuals, community members will first approach the land management committee. So anytime you are dealing with any transaction involving community land, there are two very, very important parties. There is a land management committee. It's like the executive side. Then there is a assembly, which is like the approval, the parliament for approval. So the land management then will consult with the Ministry of Land and National Land Commission. Remember, there must be involved.
Yes.
If the consent is given by the Minister of Land and National Land NLC, the land management committee would by a special sitting of the community assembly, subject to section 21(2) of the Community Land Act. So a special meeting of the community assembly. So what does section 21(2) of the Community Land Act?
21(2). So a registered community shall, before the conversion of registered community land into any other category of land, seek and obtain approval from 2/3 in a special meeting convened for that purpose.
Yes.
Okay.
So that is the pursuant, the section which is relevant here.
Yeah.
Then, of course, the approval is going to be given.
Yeah.
Then the land management committee through, remember its officials.
Yes.
Chairman and secretary will sign a transfer. It is called CLA1, application for recognition of interest to a individual community member. CLA1, if you look at the community land forms in the Ministry of Lands, study those forms at your own free time. It's called CLA1, application for recognition of interest to individual community, and attach the resolution of the community assembly. Then the final process, the land register would, after, of course, the transfer is without consideration. Remember here, these are the members of the community who are now being given the individual task. The land registrar, upon satisfaction of the documents and payment of the prescribed fees, the registration or certificates will give each and every individual title to the community member.
And do they pay stamp duty?
Of course, stamp duty is paid.
But what value would it be linked to if they're getting it for free because they're part of the community?
Stamp duty, you know, the regime for paying stamp duty is two. You know, the municipality is how many percent? 4%.
There's 2 and 4.
Yeah, the 4% for municipality.
Yes. Yeah.
And 2% for the village.
Yes.
Yes, the villages. Unaona?
Yeah.
So here, you know, this it is in the villages. So most likely it's 2% which is going to apply. But for purposes of this question, I will advise you to not to talk about stamp duty. Unaona?
Yeah.
Don't talk about stamp duty. Talk about stamp duty where you are is between a transfer between a person and a person, eh?
Yeah.
Or individuals, eh?
Mm.
Yes, avoid tactically because that is something we need to research, eh?
Yes.
Yes, you just avoid about the talking about stamp duty. So
Okay.
if you talk about those process in the way I've talked about, it's going to give you 5 marks. Eh?
Okay.
So now there is this. Of course, this question has never been tested. It was the first time it was being tested. So question 1 generally was a difficult question, eh? And being a compulsory question, you now understand why many people failed. But the topic on conversion, eh? There are various conversions which have been tested and not tested. Eh?
Yeah.
So conversion of public to private land, which is compulsory acquisition, have been tested many times. So that one, I know many people know about it. Eh?
Yeah.
Conversion of public land to private land through allocation once. Conversion of public to private land once. Now this community conversion of community land to private land, this one, and
They've
here
done it once.
once. So and there are two. Yeah, mute. So there is conversion where it is community conversion is being is conversion between from community land to privatization, where the members are of the community land. But there is an also conversion from community land to private land through transfer, where they are selling. Eh? So that one, look at it. If you look at Community Land Act and its regulation, you are going to see that answer. Eh? So,
sorry,
Kate,
so the community land to private, this is transfer to community. This is the question that we have seen here. But you're saying there's also community land to now a third party individual.
A third party individual.
Okay, not part of the community.
Not part of the community.
Okay.
Then this area has not been tested, and I want you to go and look at them very seriously. Yeah? Conversion of public land to community land. If you look at the conversion of land rules together with the Community Land Act and the regulation, you are going to see an answer. Conversion of private land to community land.
Okay.
Conversion of community land to public land. So I'm going to repeat the conversion that has not been tested. You go and look at them. Eh? Conversion of public land to community land. Conversion of private land to community land. Conversion of community land to public land. And those answers are in the Land Act, land conversion rules, community land, and community land regulations. You're going to get the answer there.
Okay.
Felix Okiri book, you have it?
No.
Second, second edition.
No, I don't have that book.
but there is online copy. Although I don't.
I have it. I can share.
Thank you very much, Helen.
Yes.
Sure.
So although I don't encourage plagiarism, this sharing of someone's sweater, but he has the process.
Okay.
So that is very, very important. Look at it.
Will you be dropping it to the chat, Helen?
Yes, to the group.
Okay.
Me to send. Should send it privately.
Maybe you drop it in this. Are you able to? Okay, let me just drop you my my email address. Yeah, that's my email address.
Okay.
Thank you, Helen.
Karibu.
So that is it. So that is the question. Then let's go to the next question. So Nyandwe bought 12. Mute, please. Nyandwe bought 12.5 acres of freehold land containing in 5 titles back in the year 1996. He was working as a farm manager for the employer, but his salary could not be able to settle the sum of 4.5 million being the purchase price. After the discussion of his employer, Mr. Brown agreed to settle the purchase price for him on condition that includes his name on each title until the entire sum is deducted. They agreed and the titles were processed. He also deducted a sum of 35,000 per month until year 2015 when the loan was fully settled. He has instructed you to write to Mr. Brown and demand the removal of his name to the from the land register. So, upon carrying out our official research on the nature of ownership, there are three of the 5 titles read equal shares, while the rest simply read 2 names, but remain silent as to the nature of ownership. Explain to Mr. Nyandwe the implication of the 2 scenarios on the claim for removal of Mr. Brown. So, Helen, what do you think the question is asking you about?
I think the question is talking about tenancy in common and joint tenancy.
Yes. So equal shares is what?
Tenancy in common?
It's joint tenant.
Tenancy, is that where the shares are defined? The share is defined. We're talking about
as undivided.
Okay.
So the question is asking you about joint tenant and tenants in common. So you must know what it is the difference. So Kate, what is the difference?
Yes. I think joint tenancy in common is where the shares are not defined. And what comes to mind is in an apartment, like say maybe the parking lot will be tenancy in common. And joint ownership is where then it's jointly owned, where it has mentioned the shares, then it joins to the extent that each is determined. Now, I think I'm not very sure, but that's what I would say.
So this is a question of 4 marks, eh?
Yes.
So you explain what is a joint tenant and tenants in common. So joint tenants, when you say joint tenants is co-ownership or equal shares, share equally. So these are special form of ownership where 2 or more persons own the same property. The divisions are called joint tenant. They share equally ownership and they have equal rights, undivided rights to keep or dispose of the property. Joint tenants creates a right of survivorship. This right provides that if one of the joint tenants dies, the remainder of the property is transferred to the survivor. So, will does not apply here. Then tenants in common, on the other hand, is joint ownership of the property where each owns a separate share in the property. On the death of one tenant, their share passes to the beneficiaries according to the will, if it is or intestacy, if it is not will, there is no will. So
I did it the other way around in answering.
Yes.
Okay. So joint tenancy. So the type of tenancy that you have for where there are apartments, is it tenancy in common or is it joint tenancy? Tenancy in common. Which one is it?
It depends on the type of ownership.
Okay.
So if each and every person have his own share, then it's tenants in common. But if any person does not have a share, they own jointly without any shares.
Yeah.
Then that is joint tenants. No.
So where there's shares, it's tenancy in common.
Common, yes. And where they are not joint tenants, there are no shares. And survivorship applies on joint tenant. You remember in your probate where, let's go to probate a bit. You remember where in areas where the will does not apply, you have read,
Yes.
It's here. And of course, we are in shares of retirement benefits or shares in a circle. So the person you have nominated becomes the person who will take the share, not what the law of succession says on intestacy. Yes, so that was the answer. And joint tenancy is defined, they are both in the Land Act and the Land Registration Act. They have been defined there. So that's why I'm telling you, someone must read and understand the Land Act and Land Registration Act very well. You have a go ahead, one step ahead in answering this question. So that was not a difficult question. This question has been tested many times. So someone who has interacted with past papers ought to have did this question well. So I go to the next, B2. Thereafter, you write to Mr. Brown, who is the custodian of the titles, to surrender the original titles, but the family lawyer responds indicating the old man rested a few weeks prior to your letter, but his youngest has a power of attorney which can be used in his place. Discuss the effects of the power of attorney in the circumstances. Helen, how do you interpret the question first?
Just give me a minute.
Yes, you can see it.
Yes, I'm trying to get it.
So, Kate, you can interpret the question?
So I think you sort of like getting a bit to the probate, but I think that's part B. But part A on the power of attorney, the effect of a power of attorney is that the person who's the donee can sign a document or can make decisions for the donor concerning the assets and the financial affairs of the donor. That is the effect of our power of attorney. And in these circumstances, because it is death, I would say it would need to be more of a general power of attorney that allows the son to be able to effect it. But one other aspect has been mentioned in this question, which is of importance, is that his youngest son. So this person needs to have reached the age of majority and need to be of sound mind. So in terms of capacity to enter, to effect a power of attorney, it needs to be that is effected. I know it's 2 marks, but so, but yeah, those are the 2 aspects. Part A.
So those are 2 marks. So you start by defining what is a power of attorney, eh?
Yes.
What you have said, eh? Yeah, is a power of attorney is donated by the donor to donee to transact on his behalf, eh? So, but there's very, very important thing you have missed here. And that's why I was telling you to interpret the question, eh?
Yes.
So thereafter, you write to Mr. Brown, who is a custodian of the titles, to surrender the original titles, but the family responds to you indicating that the old man rested a few weeks ago prior to your letter. But his youngest has a power of attorney which can use in his place to respond. Helen, what can you see the mischief in this question?
I can see it.
Sorry?
I can.
Sorry?
You see?
Okay. Yeah? So this question, this question is testing on your whether the power of attorney can be used when someone has died. So that is a mischief. That's why it's added. Discuss the effects of the power of attorney. So now with that guidance, yes.
Because it says he had a power of attorney.
Yes.
Well, but I thought the mischief was that is written to Mr. Brown. He's supposed now to do it. But how are we able to tell that the power of attorney wasn't effective on the death as opposed to prior? Like how do you apply the concept of mischief? Because it could be that he now has to write to the estate of Mr. Brown as opposed to now Mr. Brown, because it's not clear exactly when the power of attorney was issued and when it was to be effective. but it says which he can use in his place to respond. So that's why I didn't think that that's where the mischief is.
The mischief is simple. This power of attorney, when a power of attorney is given by the donor and he has died,
on death,
it ceases to have effect.
Yeah.
Yes, so, you're right. You're right.
Yes.
You're right.
Yes.
100%. Yes. Because now it becomes the estate, and yes, you're 100%.
So that's why I usually tell you, you read the question and understand the mischief. You know the question is direct you. What is the effect of the power of attorney?
In these circumstances, so it will be of no effect.
Yes. So you start by defining what the power of attorney is. Then you talk about that it will not have it only have effect during the lifetime of the donor.
Oh, the donor.
So yes, when the donor dies,
yes,
it ceases to have effect.
So it automatically is revoked on death, insanity, bankruptcy, performance, expiry of time. Yeah. Oh.
Yes. So you want 2 marks, eh?
Yeah.
So this was an easy question, eh?
But a tricky one.
Yeah. Explain the process of removing a deceased co-owner from the 5 titles. So we are with you, Kate. Now you come to where you are saying this is probate, eh?
Yeah.
Yeah.
So I think the administrator of the estate must be involved in the process of removal of the deceased, but I must confess that the process of removal, I'm not very conversant with it. I would seek your guidance or my colleagues' guidance.
So, Helen?
I believe you have to make an application. I don't remember to who, but you have to present also a death certificate. The name of that co-owner is going to be struck off the title. If you are co-owners, yes, from the titles, then both names are appearing on the title. So once you present the relevant documents, the name will be struck out. I don't know whether they give you, I think they give you a new title with only your name. Your name is this time, then you're given a new title.
Yes. Correct. And you earn your 4 marks. So, I told you conveyancing is about process, eh? Process and steps. So you must explain them sequentially. So what is the first step? You talk about the co-owner who was left. Is going to apply to the registrar of titles, of course, attaching a copy of death certificate. So, Regulation 54.1 of Land Registration General Regulation 2017 is relevant. Eh? It is where the process, you find the processes. Then, as Helen has said,
sorry, please repeat.
Regulation 54.1 of Land Registration General Regulation 2017.
Okay.
So the land register is going to strike out the name of the co-owner and issue the surviving co-owner a new title deed. Yeah, so processes in the land conveyancing general regulations are very, 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 very important. So this question is a question that is repeated many times. Last was in April 2022, question 4B. So that's why papers are usually very, very important. So a person, even if you could not have scored question 1, 1A, 1 and 2, at least here you could have gotten your, these are 9 marks. You could have gotten good marks here. So, and it balances everything. So we go to the next question. Question 2. The government of Kenya plans to expand Nairobi, Nakuru, Eldoret, Marava Road beyond the initial road is served to build a superhighway. The implication of this is that the government will acquire additional land of this project. You are the legal officer working at the National Land Commission. Advise the commission factors to be considered in making compensation to be affected to the persons. So, this is compulsory acquisition. They usually test the process, but now here is not the process. It's factors to be considered in making the compensation to the affected person. So, Helen, what do you think?
The number of inhabitants, the value. Can you hear me? Can you hear me?
Mm-hmm.
The number of inhabitants.
Yes, loud and clear.
The number of inhabitants, the value of the land, whether the inhabitants have title. Yeah, I think I remember those 3.
Okay. Good trial, Kate.
I would have the same.
You have the same, eh?
Yes.
So this is a very specific question, eh? This is a very specific question, and the answer was in Rule 3 of the Land Assessment of Just Compensation Regulations. So that's why I'm telling you, you must, the regulations are very, very important under the Land Act. So I am going to project the Land Assessment of Just Compensation Regulations. Rule 3 has the factors to be considered. You can open on your side, you have them.
Yeah. So it says the market value of the land, damage sustained or likely to be sustained by persons interested at the time of the commission's taking possession of the land by reason of severing the land from his or her land, damage sustained or likely to be sustained by persons interested at the time of the commission's taking possession of the land by reason of the acquisition injuriously affecting his or her other property, whether movable or immovable, in any other manner, or his or her actual earnings. Reasonable expenses incidental to the relocation of any of the persons interested or who will be compelled to change residence or place of business as a consequence of the acquisition, and damage genuinely resulting from diminution of the profits of the land between the date of publication in the Gazette of the notice of intention to acquire the land and the date the commission takes possession of the land.
Yes. So that was the answer. This was not some of the question you think about, eh?
Yeah.
This was apart from the market value. I think the other 4 factors, I can tell you, there are many. I know many we would not have known the answer apart from market value. So that was the answer. And that one that is a question I certified that to be a difficult also question.
Mm.
So Martin, question 2B. Martin is a resident of Kitengela Township and identify a plot measuring 50 meters by 100 within Kitengela Township. The plot is going for 1,400,000 Kenya shillings, according to the information provided by the real estate. In addition, Martin has approached the Commercial Bank for financial accommodation in purchasing the plot. You are the legal officer employed at the KCB. Provide a legal opinion to the legal manager, focusing on the main points on what should be done to protect the bank interest in the contemplated transaction. So this is also a legal opinion, and a legal opinion done within an organization. You do it through an internal memo. This is legal and writing, legal writing and drafting class. But when you're dealing with you're doing a legal opinion to a lawyer outside your organization or a law firm or a client, you do a letter. But within the organization is an internal memo. So this is an internal memo from you as a legal officer to the legal manager of the bank. So, Kate, how do you interpret this question?
Sorry, I'm not seeing it on the screen, so I'm trying to see if I can get that paper somewhere else. You
Okay,
stopped sharing the question.
Okay, let me share. Sorry. So, yeah. Read and interpret.
Martin is a resident of Kitengela, has identified a plot is going for 1.4 according to the information. In addition, Martin has approached KCB for financial accommodation, purchasing plot. You're employed at KCB, provide a legal opinion to the legal manager, focusing on the main points on what should be done to protect the bank's interest in contemplated transaction. So the first thing would be.
No, I don't want to give the answer.
Yes.
I want you to see your reasoning, your interpretation. Because if your interpretation is okay, you will be able to answer.
So my understanding is that, or my interpretation is that this is a resident who wants to take a loan to buy a piece of land. So they've approached the bank. So the bank, through the legal officer, would want to find out if they release the 1.4, what protection do they have? So here, in my view, you approach it from the security charging of the property would be how I would approach this question.
Yes. Would that be enough to give you 5 marks?
So I would answer it in the same way you've guided us in terms of steps. So, and the first step is identifying the ownership of the title, because in this case, Martin is not yet an owner. So there is another vendor. So a confirmation of that, do they have the rights? There has to be a search. Then there has to be.
There's an echo.
Yeah, it's not on my end. It has stopped. Okay. So so then there needs to be a sale agreement in place.
So you see.
Yes.
Suppose there.
Okay.
So here you are that to protect the bank interest. That is the key word. So you have a very good one point is So, of course, doing a legal opinion, for the first point is to identify the seller if he has the title to the land.
Mhm.
So that is one point.
Then the next would be to undertake the search because of what the law says, that the document of truth is the records the registry has. So I would want to check that. Then I would want to have a sale agreement in place, because any land transaction, for it to be valid, it must be written. So it means that there must be a sale agreement existing between Martin, the resident, who's the banker, and now the owner of the land. Then I would.
That's a second point.
I thought it's the third one, or the first one is okay. Then the next one is to require that before the money is released, that the completion documents are delivered to the bank, signed but undated, so that then we are able to have control of the transfer. I would then recommend to the bank, I think that's my fifth point, that in registering the title, that both the names of the bank and the Martin are jointly registered, and to register the interest of the bank in the form of a charge. Yeah.
Yeah, very good. You have done well. I'll give you maybe four out of 5. So Helen, what do you want? Would you add or something?
As I was looking at it, my answer is a little bit different. Maybe it's wrong. But I mean what I was thinking.
No. The Katie's answer is correct.
I'm saying maybe my answer is wrong. Like my thoughts were a little bit different.
Okay.
I was thinking.
And you have an echo, eh?
Really?
Yes. Try to fix your microphone.
Okay.
Or your Zoom, or your the phone, the gadget you are using, eh?
Maybe it's the gadget.
So Kate, eh?
Yes, Mwalimu.
There's something you have omitted very important, eh? Remember, you are looking at the protect the bank interest. So you must talk about the background check to ascertain Martin capacity to repay the loan, eh?
Yeah.
Remember, we have not been told about the sources of income of Martin, eh?
Fair enough. Yeah.
Yeah. So not every person can go to a bank and secure a loan, eh? So they must do a background check to be able to ascertain whether he has the capacity to pay.
Okay.
Then, of course, you have talked about they finance the plot and create an encumbrance, a charge over a form of charge. You know, there is informal charges and formal charges over the property.
Yes.
Section 79.5. So that is another protection. That one you have talked about, and I'm just adding some meat. No. So you finish by saying that this, if Martin is not able to pay the loan, the bank remedies under Section 90 of the Land Act will come into play. So which includes even selling the
property.
the property under statutory power of sale.
Yeah.
So that was the answer, eh?
All right. Thank you.
And you get your full 5 marks, eh?
Yeah.
This was not a difficult question. Someone could have even gained 5 marks. So you see how conversing they are balanced. They are bringing it difficult and easy question, eh?
Mm-hmm.
Yeah. So that part B was easy. So we got to the last question of the day.
Mm-hmm.
Question 3, which I'm going to read. Nyan and his wife Anita entered into the sale agreement for the purchase of land, registration number Mavoko Town 2. It's dated 20th June 2018, and the purchase price was agreed to be 6.5 with a deposit of 4.5. The good couple paid the said deposit and waited for the vendor to subdivide the property to exercise a quota and transfer them in exchange of the balance of the purchase price. Unfortunately, that never happened to date, despite the purchasers' follow-up with the area chief, police, and deputy commissioner. They have only one desire: settle the balance and receive title registered in their respective names. Explain the procedure to ensure the property is immediately secured so as to have the legitimate expectation met. So, Helen, interpret the question, eh? Don't answer, interpret it, eh?
Is there still an echo?
Yes, there is still an echo. Kate, interpret the question.
So here, I think when I read this, it's that it's performance. So here I would say it is they're seeking for performance of the sale agreement, that because they had paid the money, that the vendor subdivides and give them their piece of land so that then they can pay the balance. That's how I would interpret this.
So,
unless, yeah.
So, yeah, it's still there.
Okay.
You use Kate, we are using a laptop, eh?
Yes, I'm using I have a headset, but I'm on my laptop. Yes.
Yeah, so Helen, you are using your phone, eh?
Yes.
Yeah, so from tomorrow, go to use a laptop, eh? Or if you don't have a laptop, you I don't know what you are going to do, eh?
I'll use a different gadget.
Yeah, so because the next two before your exam, it will be very intense, eh?
Okay.
Next week is commercial, and then we finish with legal writing and drafting, as I had said. So I don't want you to miss, eh? And to participate. So explain the procedure to ensure the property is immediately secured as to have legitimate expectation. So you have interpreted a bit, Kate. But the question now A is asking, explain the procedure to ensure the property is immediately secured so as to have legitimate expectation. What do you think is your answer?
So I think to secure the position of the couple, I would request that they do a caveat. And so then what I'll be indicating there is the process of having a caveat. I would, here's what Mr. Odera was saying, a notice to the vendor. There's what that notice is for them to perform. So I'll do a caveat and then I would write a notice for them to perform. Yes.
So,
but the
yeah,
process, I'm not very sure on the steps completely.
So that is the answer. Is the question was because remember the question usually is talking about the procedure. I told you the steps, procedure, and yeah, procedure steps. Those are the words that is used in conveyancing. Process. Always remember each and every question at the back of your mind. You must talk about, even if it is not asking you that. In any conversing question, unless the question is very direct, like two-way, the factors. But any question that is a problem question, you must talk about the process, procedure, or steps. So this is a question. So they are going to put a question. So that is the answer. Then you explain what is a question. It is defined in the Land Act and the Land Registration Act, one of them or both. A caution is a notice registered to effect no action of a specific nature in relation to the land in respect which notice has been entered may be taken without informing the person who wrote the caution. So after defining what a caution is, you talked about process of registering a caution. So Section 71(3) of the Land Registration Act. So around state that the caution shall be prescribed formed, and the registrar may require a cautioner to support the caution with statutory declaration. So they are going to do a caution and support it with the statutory declaration, an affidavit. So the application is Form R67 in the regulations. So then you take the application and the affidavit to the registry. Then the caution is registered in the appropriate registry against the title. Then the cautioner make a search to make sure that the caution has been registered. So that is the process.
Yes. So I see the Act says that the registrar gives notice of the caution to the proprietor. Is the role, is it the registrar's role, or is it now the person placing the caution who will be now serving the vendor with the search results of the caution?
It will be so sometimes what the act says and in practice, they don't go together. So it is the person who has the interest, the caution,
yeah,
who's going to serve the person. Yes. So this is a repeated question many times in the past. Latest question 5, April 2022. So this is a question I did not expect someone to fail.
Okay.
5 marks. You earn your free 5 marks there. So 3B, upon carrying out official search against the contract property, he realized that the property was indeed subdivided and the portion sold. However, there is a quarter an acre remaining, and the historical search shows that an entry made in the year 2022, a few months after the police report declaring the title lost. 2 years later, and the record is the same, but the purchasers remain intent to acquiring the land against all odds. Advise them on how they can fulfill their desire in view the fact that the vendor is still unresponsive. So, Kate, what do you think? Interpret the question.
This is a hard one in terms of in my mind, it becomes difficult to maybe place a caution. Because one subdivision has been done and a portion of it sold, like what do you know is the piece that was there? Advise them on how they can fulfill their desire in view of the fact that the vendor is still unresponsive. I think I would say take them to court for specific performance, but I'll take your guidance on it.
So that is the answer?
Okay.
The answer was specific performance.
Okay.
So you explain what is a specific performance.
All right, all right.
What is specific performance?
Specific performance is a right that can be exercised by the non-defaulting party for the defaulting party to do or to not do a particular act with regards to their obligations in an agreement.
Okay. So what? Okay, continue.
So what I would do now is I would institute a suit. But before I institute a suit, I would do a notice, a written notice to the vendor that within a particular period of time that they need to have proceeded to do the completion of the transaction, to do the act. And if they don't, I now indicate within a fixed period of time. Then if I don't, I institute a suit. Yeah. So, and then of course the process for institution of a suit, the plaintiffs use the documents and all the evidence that is there. So that would be how I would approach it.
Yes. So that was the answer. So you first of all talk about what is specific performance.
Okay.
So is an equitable remedy for breach of contract.
Yes.
Where damages is not adequate.
Okay. Yes.
Yes. Remember.
Yes.
Yes. Remember this question. They are saying they are still they can fulfill. They still want to fulfill their desire.
Yeah. Yeah.
Yeah. So when you talk about specific performance, is an equitable remedy against breach of contract. A declaration made by court to compelling the party to perform its contractual obligation.
Obligation. Yes.
Yes. And is granted where damages is not adequate remedy.
Sufficient. Yeah.
Yes, sufficient remedy.
Yes.
So you talk about, of course, it is done through a plaint. You can also talk about originating summons. Remember, under your civil litigation, a dispute between seller and buyer can be brought through either a plaint, like here, or originating summons. So then, of course, the court is going to hear the case and order the party to do the transfer to complete their part.
So from practice, Mwalimu,
Yes.
which is the better route, plaint or originating summons?
Either can do.
Okay, so one doesn't. But under originating summons, you would be able to do a certificate of urgency.
Yes.
As opposed to plaint.
Yes, yes. It's just like the same. You see.
Okay.
In divorce proceedings,
Mm-hmm.
you can do a petition or a plaint.
Okay.
And a plaint usually when the divorce is done in the chief magistrate court.
Mm.
But a petition it's of course in the High Court family division, especially there is of course there will be a determination of division of matrimonial property.
Mm.
You know a divorce can be of course the same can be brought together with division of matrimonial property and where the property is more than 20 million.
Yeah.
That's why you go to the High Court. So it is a plaint or originating someone's either can do it.
Okay.
But
Understood.
as you are saying, the certificate of urgency is usually done in originating someone's.
Yeah. Okay.
Then you say that it's very very important that if these parties, the vendor is refuses to sign the transfer agreement, the deputy registrar
Mm-hmm.
can be ordered to sign on their behalf. You know that?
No.
Yes, if
I
they refuse, the
think
deputy
we can
registrar become now the vendor. That is why it is
opportunity
specific
the same.
performance.
Yes. Yes. Yes.
Yes, yes, and you earn your 5 marks.
Mm. Wow.
So, so this was a question that has never been asked before. But of course,
Oh,
someone who is
this
good.
has never been asked.
Yes, in conveyancing. But of course,
Okay.
a good student of civil litigation will answer it.
Yeah.
Like you know its specific performance. So now,
Yeah.
so Jen, we have come to the end. Let me stop the recording.
Mm-hmm.